Welcome back to the Emily Show. Today we are back in Massachusetts. It seems like even though this case has gone to trial, it is just not over, and that is the Karen Read case. And of course, with a new ABC 2020 interview dropping on Friday, and that being discussed all around both legacy media, well, owned by ABC, and traditional media, newspapers, print, and the internet, we are going to talk about it. But there was also a motion dropped on Friday by the Commonwealth regarding Trooper Proctor's work cell phone. And I have a lot of thoughts about that. If you listened to Quick Bits this week, you might have gotten just a little bit of what's going on here. Today, we're going to go through what Adam Lally filed and some of my concerns about what's happening with Trooper Proctor's work cell phone, the implications it has for the retrial of Karen Read. And then we're going to talk about the 2020 interview with Karen Read and exclusive never be seen footage of her closet before she went to trial. So we're going to talk about all the things Massachusetts today, and we should just get right into it. Welcome to the Emily Show. I'm Emily D. Baker, the internet's go-to legal analyst and big fan of the cursey words. I've been a licensed attorney for over 17 years. I'm a former prosecutor, and I break down the legal side of pop culture and entertainment stories we can't stop talking about. We should just get into it. Let's go. Thank you to Lume for sponsoring today's episode. If you haven't tried Lume yet, I don't know what you're waiting for. Lume is a whole body deodorant that has you covered from your pits to your parts to your feet and everything in between. It was created by an OBGYN, so it is safe to use wherever you want to make sure that there is no odor there. And if you've wanted to try Lume's full range of products, everything from their body wash that also works to reduce odor to the amazing deodorant wipes that you can throw in your kid's backpack for band practice. Wow, Emily, that's an oddly specific example. Yes, it is my life. To their deodorant stick or their deodorant in the tube, you can try it all with their starter pack. And you can choose everything from lavender sage to unscented to clean tangerine or soft powder. So you know there's going to be a scent that works not just for you, but for everyone in your household. And as an offer to our listeners, new customers get 15% off all Lume products. And if you're interested in their starter pack to try a variety of products, you get the discount from the starter pack and the 15% off, which is over 40% off the starter pack. So use code LAWNERD for 15% off your purchase at lumedeodorant.com. That's LumeDeodorant.com. Let's get back to today's episode. The first thing we're talking about today is Trooper Proctor. As you may remember, if you watched the trial, and if you're like, girl, we missed the trial, I need the TLDR. And for those of you that are like, I don't even know what a TLDR is, too long didn't read. It's why we made Quick Bits, because most of my streams need a TLDR version. But the TLDR on Trooper Proctor is he was the case investigator or the lead investigator of the Karen Read case. He's also an investigator and lead investigator on other high-profile cases in Massachusetts. On Friday, September 6th, the Commonwealth filed a notice. It's not really a motion. It's a notice to the court and to defense counsel regarding Trooper Proctor's work phone. During the Karen Read trial, Trooper Proctor, who was the case agent, had his personal cell phone downloaded and had quite a lot of derogatory messages about Karen Read, talking about her very early on in the investigation, making disparaging remarks, laughing about her medical conditions with supervisors, talking all about her to his group text of buddies, amongst other unflattering text messages. And then when he testified, I don't know how you felt about it, but when he testified, this is how I felt. His response to these text messages showed that he, A, had no remorse about them. B, I think he still stands by what he said. And he said that they were juvenile and inappropriate jokes, but they did not impact his investigation into Karen Read in any way. He seemed not to have any remorse whatsoever. And every time Adam Lally asked him, did these text messages impact your investigation? He's like, the text messages were juvenile and they were jokes, but they did not impact the testimony. I'm like, you know what's going to impact Trooper Proctor's testimony is whatever happens in this federal investigation, because the fact that they were even able to get into his personal cell phone, that things happened enough that they were able to access his personal cell phone is wild. It is very uncommon that that happens in cases with officers that work on cases. However, if an officer takes photos of a crime scene with a personal cell because they don't have a camera on them, they don't have a work phone or whatever it is, it can open up their phone to discovery. Trooper Proctor's phone was opened up to discovery due to the nature of his text messages, and it seems that that was disclosed partly in connection with the federal investigation. But without going down a rabbit hole on how we got here discovery-wise, it is incredibly unusual that the text messages of an officer are discoverable to the defense. But now Trooper Proctor's text messages are very much the issue in all of the cases he is connected to. I imagine that the Norfolk County District Attorney's Office is going to be trying to make sure that whatever cases Trooper Proctor is on, including the Brian Walsh case, that he has as much of a minimum role in it as possible. And of course, he has been relieved of duty and suspended without pay while the due process is ongoing. I think ultimately he will be terminated. I think they're really trying to figure out what to do, but it's not just Trooper Proctor. State police clearly has some shit that they are going to have to deal with in Massachusetts, and defense attorneys have to be asking for this and this type of discovery in every single state police case. If you were a defense attorney in Massachusetts right now, you would be saying, well, what's going on with the staties on my case? Like, what more do we need to know? What if the trooper on my case is doing the same stuff we're seeing in the Karen Reed case? Or what if state police is, I don't know, extracting a cell phone and they say they got it all? And then we're seeing in the Sandra Birchmore case that state police downloaded all of the defendant police officer's phone, but missed 30,000 text messages, over 30,000 damning text messages that clearly prove that the conclusion their investigation came up with is not what their conclusion should have been. So now in every case that's being investigated by state police, these things will come up and defense attorneys are going to make motions asking for this, and they have basis to do it. The Norfolk County DA's office has to be getting inundated with motions regarding cases investigated by state police. And with Trooper Proctor, he was like embedded in the Norfolk County District Attorney's Office. So there are state police working within the DA's office that do the investigations, which is part of what causes me so much concern about this motion getting into Trooper Proctor's personal cell phone. Emily, that was the longest TLDR ever. I told you I had thoughts. You're not here because I'm concise. So let's take a look at this filing by Adam Lally regarding State Trooper Michael Proctor's work cell phone. What's so wild about this notice to the court is it just says Commonwealth's updated notice regarding State Trooper. They don't even name him in the beginning of it. We know who you're talking about. We all know. So let's go through this motion together. The trial of the Commonwealth versus Karen Reed, case number ending 117, began in Norfolk Superior Court on April 16th, Beverly J. Cannoni presiding. Trooper Proctor testified in that matter on June 10th and 12th, 2024, and was subject to cross-examination relating to alleged conflicts of interest, communications with non-involved civilian persons regarding the Reed case, and statements regarding the defendant from which defense counsel argued a bias could be found. I mean, we've missed a few things, but I guess we're being succinct. On July 22nd, 2024, the Commonwealth informed counsel and the court that Trooper Proctor had been suspended without pay and was the subject of an internal affairs investigation. On July 22nd, 2024, the Commonwealth provided an unofficial transcript of Trooper Proctor's testimony in the Reed case to counsel. On August 29th, 2024, the Massachusetts State Police provided an extraction of Trooper Proctor's work cell to the Norfolk District Attorney's Office. On September 4th, the Massachusetts State Police provided content from Trooper Proctor's work cloud account to the Norfolk District Attorney's Office. Based on the Norfolk District Attorney's Office preliminary review of the data, and because the extraction of the Proctor work phone and cloud is expected to contain, among other things, information about open investigations, surveillance video from unrelated investigations, personal identifying information and or medical information of individuals involved in unrelated investigations, location data of Proctor and third parties, releasing the entire extraction report outside of law enforcement is anticipated to jeopardize open investigations, compromise the privacy and safety of civilians, and thus be contrary to the interest of justice. There is a footnote on that. Accordingly, the Norfolk District Attorney's Office is in the process of ascertaining how to determine what, if any, information on Trooper Proctor's work phone or cloud account is discoverable in this and other cases. And then there's another footnote. Am I being trolled by this? Are we writing what, if any, in the motions? So the district attorney's office is in the process of ascertaining how to determine what, if any, information on Trooper Proctor's work phone or cloud account is discoverable in this and other cases. I am going to read the footnotes. Here is my concern. I don't know if the Norfolk County District Attorney's Office should be making this review, who is making this review, how they are cordoned off from the teams involved. I have a very specific perspective on this because of the way I worked as a prosecutor. We had district attorney investigators. Those investigators helped us find witnesses, subpoena witnesses, helped answer our questions. They did not investigate the cases 99% of the time. There were very, very limited circumstances when they were doing any investigation. They were often retired from other agencies, sometimes from other states, but they weren't investigating the cases. They were assisting us mostly in dealing with witnesses and some in helping us understand and ascertain information that we were taking in from our other law enforcement agencies. Law enforcement and their separate agencies would investigate. They would present the case to us. We would review the case. If there was not enough information to file a case, we would say, we need more information on this. If we had questions about the investigation, we would ask. If we had questions about who would be testifying, we would ask. But we weren't working hand in hand with members of our office to do those investigations. And then we were the ones picking the charges and prosecuting. So there were more checks and balances looking over a case than investigating it along with the attorney that's going to be filing it. When you see how closely Trooper Proctor and the DAs are working together in the Norfolk District Attorney's Office, how is there any checks and balance on the investigation when everybody's working hand in hand? Sometimes it's really hard to evaluate your own work, especially if you feel very close to it. And we saw this highlighted a bit in the 2020 episode for me, where you see Adam Lally saying over and over again, Karen Reed said, I hit him. But on cross-examination, there were lots of questions about that statement, but you could see how deeply invested the prosecutor was into the prosecution, that even those statements that are, I think, not clear when you look at all of the context and the contrary statements by witnesses, I don't think Adam Lally viewed those statements as anything other than definitive admissions. And I think that was an error. But when you're too close to something, often errors can be made. When we're looking at the Norfolk County District Attorney's Office, they work with 27 cities within Norfolk County. I realized that I worked in one of the most densely populated counties in the US. So I appreciate that from my perspective, other counties are small. This is not a small prosecutor's office. They have, according to their website, over 130 employees. Not all of those employees are going to be district attorneys. That is going to be all of their total employees. And they prosecute about 20,000 cases a year. The Los Angeles County District Attorney's Office, per their website, runs between 180,000 and 200,000 cases per year, When I was there, they still had upwards of 1,000 attorneys. I think closer to 3,000 total in staff, but it's a much different setup. And the law enforcement setup is clearly different, where you've got, Los Angeles County sheriffs plus LAPD, but then other cities have their own police departments. It's very different than all of the homicide prosecutions go to the investigators that are embedded within the district attorney's office. And so they're working them hand in hand with the lawyers that are going to be prosecuting them. And then who is taking a look at the cases and double checking? Where are those checks and balances? Every attorney needs fresh eyes on a case, especially if you are in the investigation. And we could see from early in this investigation how deeply invested Trooper Proctor was from his earliest text messages hours after this investigation began, saying that she's the one that did it. So when we're talking about bias, we can put the name calling aside for a moment and just look at the conclusions that were made. If that's what he was saying on his personal cell, what was he putting on his work cell? I can completely understand why the defense is like, I want all of it. And I won't be surprised if we see defense motions saying that the Norfolk County District Attorney's Office shouldn't be choosing what gets turned over here. Either, I don't think this is ever going to happen. Sometimes you can have these things reviewed in camera, in chambers, privately by a judge. With cell phone data dumps, that's not practical. But having someone outside of Norfolk County DA's office, outside state police, evaluate what should be turned over or not seems maybe to be the better option. The only small glimmer of hope I have here is it says that the district attorney's office is in the process of ascertaining how to determine what, if any, information on the work phone is discoverable. That should go to either, I don't know if they have multiple offices, DAs who have not touched this case at all, a separate wing of law enforcement that hasn't done this at all. But it feels like somebody more distanced from this case needs to review it, because anything with regard to the Karen Reed case should go to the Karen Reed attorneys. Anything with regard to the Brian Walsh case should go to those defense attorneys. But no, Trooper Proctor's location data outside of the investigation from the Karen Reed case, because I think Trooper Proctor's location data from his work phone in connection with the Karen Reed case is highly relevant. But outside of the days that he, was investigating that case, the year before, the months after, aren't necessarily relevant and could disclose ongoing investigations, which could put people in jeopardy. It could also, a lot of people are investigated that are never charged. Having that shit splashed all over the internet isn't good for those individuals either. There are some things that should be protected here. I agree with that. I don't agree that the district attorney's office, unless they cordon it off and put a wall up between the individuals that are doing this review and the individuals that work the Karen Reed case, I think it needs to go out of those involved with the case specifically. And I suggested on Quick Bits, lots of cases bring in attorneys to evaluate cases that have materials that are attorney-client privilege and other things. There can be a discovery attorney appointed that is a private attorney outside of any of these cases, and that might not be a terrible idea here either. There has to be a better way, and I hope that when they say they're ascertaining how to determine, they're determining how to determine what's discoverable. I hope part of that conversation is having somebody very far removed from this case evaluating these things. Let's look at the footnotes, because they're like an entire page, single spaced, of footnotes themselves. The footnotes are an entire separate page. Footnote 1 says, the phone and cloud account may include sensitive and confidential communications and information regarding unrelated cases and active investigations. This information may include criminal offender record information, the names and contact information of confidential informants, names and contact information of civilian witnesses and victims, including minors, impound search warrants, status updates of covert ongoing investigations, information about ongoing grand jury proceedings. There's only one grand jury I really want to know a lot about when it comes to all of this that we don't know about yet. Autopsy records and photographs. I mean, maybe from the cloud account, and other sensitive privileged information that, if disclosed, would not only jeopardize law enforcement efforts, but could pose a physical safety risk to individuals and the public alike. And then they cite case law stating, under public records law framework, purposes of investigatory exemption include, quote, premature disclosure of the Commonwealth's case prior to trial, the prevention of the disclosure of confidential investigation techniques, procedures, or sources of information, the encouragement of individual citizens to come forward and speak freely with police concerning matters under investigation, and the creation of initiative that police officers might be completely candid in recording their observations, hypotheses, and interim conclusions. They cite other case law. Why they didn't just cite the case law in their notice, maybe it's because it's an update. I don't know. Undisclosed witness information is confidential as to foster an atmosphere where citizens feel free to cooperate with police. It says a defendant's unrestrained access to these devices would also likely violate statutory privileges, serving to protect unrelated cases, investigations, witnesses, and victims. I agree, there is a reason to go through all of this information. Some of it will not be discoverable. You don't just wholesale turn over all of it. But who is deciding is my biggest question. And I wonder if we'll see a motion about that. And I wonder if we'll see defense attorneys raising concerns about that. It goes on to say the Norfolk District Attorney's Office is exploring hiring an outside firm. Emily, you should have kept reading. I'm so excited about this. Well done, Commonwealth. Well done. Buried in footnote 2, the Norfolk District Attorney's Office is exploring hiring an outside firm to examine the phone and cloud data to ascertain what information is discoverable. Right, like a discovery referee, a taint attorney, someone to make sure that what is turned over has been evaluated. It said on September 6, 2024, a Zoom hearing was held in the Commonwealth versus Julius Hammond Desir and Samantha Schwartz, which is currently scheduled for jury trial in October 2024. Trooper Proctor had minimal involvement in that investigation and is not expected to testify at trial, nor did he testify before the grand jury. It goes on to say on September 6th, the Commonwealth reported to the court that it was in possession of Trooper Michael Proctor's work phone and cloud. The court and defense counsel indicated it was the Norfolk District Attorney's Office obligation to search the phone extraction, and pursuant to the court's discretion, the Norfolk District Attorney's Office will begin searching the data for bias and Rule 14 material pertaining to that case. So this is happening in every case that Trooper Proctor is on, and Trooper Proctor handled murder investigations and unattended death investigations for the Norfolk County DA's office. This is a huge problem for them, and I think if the courts fought them on an outside firm, that would be wild. An outside firm is the only thing that makes sense to me. So moving on from all things Michael Proctor, even though he was featured a bit in the 2020 episode with ABC focusing on Karen Read, let's talk about Karen Read on 2020. I'm going to give you my thoughts. We're going to talk about how this could or could not impact a new trial. Alan Jackson sure had a lot to say, didn't he? And there was some interesting information about how he ended up taking this case. And he had some very strong words about his perception of Karen Read's innocence in this case. Thank you to today's sponsor, Shopify. Shopify supports the Emily Show and all of my content, and they support the Law Nerd shop, which I made on Shopify. When y'all were like, let's have some Law Nerd merch, Shopify makes it incredibly easy to get a shop up and running no matter what you want to sell and no matter how you want to sell, whether you're selling in person, online, or a combination of the two. And it's no wonder, because Shopify has the #1 checkout on the planet, and they let you use Shop Pay, which I have on the Law Nerd shop, and I also use it when I'm shopping around the interwebs. So whether you're just getting started or whether you're looking for a more robust way to run your store, Shopify is ready to help you upgrade your business. And you can do that and get the same checkout that the Law Nerd shop has with a Shopify trial. Sign up for your $1 per month trial at shopify.com/lawnerd. Remember, that's all lowercase. Go to shopify.com/Leonard to upgrade your selling experience today. That's shopify.com/Leonard, and you'll start hearing this sound soon. So let's get back to today's episode. ABC released their 2020 episode on Karen Read called The Perfect Storm. I have thoughts. You know how I feel about the media, maybe making things more sensationalized than they need to be. But of course, with all the talk of the snow at the trial, I'm not surprised that it was a perfect storm was their title to this episode of 2020. They showed so many shots of just snow or windshield wipers, recreated B-roll of snow and windshield wipers on the snow. They did replay some of the footage from the trial, from some of the police officer cameras, from their vehicles. They played clips of different witnesses from the trial. They had a lot of commentary in this episode and not as much of Karen Read's interview. But there were parts of this episode that did have a few moments of Karen Read's interview. And as I watched through it the second time, I wondered more when that interview was recorded. And there is a point in the interview where they go to a marker. Yes, I paused it to see when it was recorded because it's on the marker. And it was recorded on July 24th, 2023. And there was one indication where the reporter who sat down and interviewed Karen Read, who narrated a lot of this episode, said, and this is the point when I sat down with Karen Read. So indicating that the interview was not recorded contemporaneous to her going to trial, but it was actually recorded almost a year in advance of the trial. So knowing that it was recorded almost a year in advance of the trial makes the interview make a bit more sense in some of the things that she said, some of the things that she didn't. But it's hard to really gather what was said and what wasn't because it's edited. I don't see jump edits the way we did after the Amber Heard Johnny Depp trial when Amber Heard sat down with Savannah Guthrie for an interview. But I see that there are question, answer, and then it goes to commentary. And so it's snipped down into bits at the beginning, and then there's a few more contiguous questions towards the end of the episode, but it's not a sit-down interview with a natural flow of conversation back and forth. It is very much an interview from 2023 interspersed into reporters, commentators, filling in the story of the trial, clips from the trial, clips from outside the courthouse, and weaving in that story. What I appreciate that they did well is they also spoke to John O'Keefe's family members and friends, and they did bring in clips of John O'Keefe, his life, how he ended up taking care of his niece and nephew. They covered and talked about his wake and what finding out that he had passed was like for his friends and family. So of everything I've seen on this case, this did bring in more of a focus on not just who John O'Keefe was, but giving a voice to his family. And in giving a voice to his family, there was much discussion about what going to court was like for them and video footage of them getting jeered and screamed at outside of court, which is absolutely wild to see. I just can't think of a circumstance where it occurs to someone to like scream at a victim's mother outside of a courthouse or at his sister's friends who are there supporting her. There are two sides to this case, and no matter what the district attorney's office does or does not prove in court, something happened to John O'Keefe. He did not die of natural causes. Something happened. So the vitriol towards his family, with all of the information that I have sitting here recording this, doesn't make a lot of sense to me. And I think two things can be true at once. You can have a circumstance where you feel that this was not a well-done investigation, that law enforcement shouldn't be proceeding with this, that there are so many problems in this investigation that the prosecutor's office shouldn't be proceeding with it. But that doesn't change how his family should be treated, or at least not harassed when they go to court to try to figure out what's happening in this case because they've been through the unthinkable as well. So there's a lot to that. And it's interesting to see how much ABC did touch on the protests outside of court, the supporters of Karen Read outside of court. They didn't focus on that in a positive way. They did talk about never seeing anything like that before in a case. And I think the Johnny Depp trial definitely had a lot of folks outside. There were llamas. There was definitely screaming at Amber Heard when she arrived at the courthouse. It's different in this case, but there are still crowds of people clearly rooting for one side over the other, like there were in the Johnny Depp and Amber Heard case. But the vitriol in this case is not just directed at the parties, it's directed at the victim's family. It's very odd watching them break that down and talking about that fervor being stirred up online and touching on that in this 2020 special. But then they didn't touch on much of Brian Higgins, Brian Albert. They didn't touch a ton on Trooper Proctor, a little bit, but not a ton. They definitely showed footage of the leaf blower blowing snow around, but nobody seemed really troubled by it. The commentary in the episode was this was a dynamic crime scene, and one of the reporters that was giving comment said the evidence was changing by the hour, and I was sitting here going, it shouldn't be. The evidence shouldn't be changing. It's snowing. The crime scene is dynamic due to weather, but that shouldn't change the evidence. That could potentially destroy evidence, make it difficult to recover evidence. It was just an interesting way to say it. But again, I watched all 9 weeks of this trial, so I am probably more critical than the casual viewer of 2020. What's interesting to me is that in the interview with Karen Read, there was not a lot of discussion of the defense theory about what happened in this case. And given that this interview happened in July of 2023, it makes more sense. You hear Karen Read talking about the fact that she thought John got hit by a snowplow. You hear her talk about the fact that she waited in her car outside of Fairview for over 10 minutes after John left her vehicle, looking for music and waiting to hear from him. They never quite explained what she thought was going to happen that night in a way that was super clear to me, but it seemed that she was going to drop him off and he was going to go inside and decide if he was going to stay at Fairview and then come back to the car and tell her, or call her and tell her. And then after 10 minutes, she was like, no, I'm out. Like, I haven't heard from you. You're in the house partying and you're just leaving me sitting out here. So I'm out. That was the sense that I got from the parts of what she said that was played. But it was interesting that timing on some of it was different than what we saw at trial when all the cell phone stuff came out. But it wasn't a huge difference. But the sitting outside the house for like 10 minutes was different based on some of the witnesses. But she was sitting outside of the house for a period of time. And then again, you have to ask the question, if she's sitting outside the house, what does the prosecution think was going on during that time? Because they seem to think that John O'Keefe was sitting in the car with her and then got out of the car, and then she backed up and hit him, and the defense said he went into the house. Everyone in the house says he doesn't. It's such a difficult case to distill because so much happened at trial and the jury didn't come back with a verdict, and there still aren't any, at least for me, really clear answers. I think the most clear testimony was from the federal government's hired biomechanical engineers and pathologist. That seemed to be the clearest answers of the case. And with regard to the competing pathologist, both of them were pretty clear that there was a traumatic head injury that could be caused from a head being hit in a variety of ways, and hypothermia. And there weren't injuries to the trunk of the body. There weren't injuries to the hips and legs where you would expect to see injuries if somebody was hit by a car. So there still were questions, lots and lots of questions. Did this 2020 interview with Karen Read answer any of those questions for me? No. When I was watching this, one of the things I was looking for was, does this give any illumination on why Karen Read may or may not have testified? And will she testify when it comes up to a retrial? And what was hard for me to evaluate is whether Karen Reed was speaking fluidly to the interviewer, whether she was speaking in sound bites because she knew she was being recorded for television. And because they edited down the interview and interspersed it throughout the explanation of the case, it was hard to get a fluid sense for anything beyond a 1 or 2 sentence answer. And some of those were very big responses. But is that because you're being filmed for TV? Or is that because you're trying to get your point across when everyone's been talking about your case except for you? Yes, she has an absolute right to talk about her case. However, I wonder if when they knew this was going to be released after trial, they thought that this was going to be released after an acquittal. Because Alan Jackson's interview with 2020 said there is no way she will be found guilty. He also said that he has never been more sure of anything he has ever said in court than what he said in this case, that there is a conspiracy, that there is a cover-up, that some of the people in the house participated in a murder, some of the people in the house, Fairview, covered up a murder, and that Karen Reed is absolutely innocent. Very, very strong words from his pretrial interview. And I wonder if all of this is going to exaggerate the 2 weeks it took them to find a jury last time. And in a retrial of a high profile case, that's always a problem. You've got the issue of how do you retry this case with a populace who may have thought, hey, I don't know if I'll ever get called for jury duty or not. So I'm just going to kind of stay away from the interwebs of it all. And once a jury's picked and it goes to trial, then I'm in, right? Finding a jury for a retrial in January is going to be difficult. Things like this will make it more difficult. But then again, the trial was streamed. So people who are interested in the case probably already watched the trial, and 2020 might not make it better or worse. But now we have statements from Karen Reed. Could the DA use those when it comes to trial? Well, it really depends on what evidence comes out at trial and if Karen Reed chooses to testify. The prosecution can use statements against interest. I didn't really see any statements against interest in this interview. She vehemently maintained her innocence. She said there's no way she hit John O'Keefe with her car, that she didn't accidentally hit him with her car, that it's not possible that she could have backed into him and not noticed, that even though she was angry at him, that she didn't form the intent to hit him with her car. She didn't want to hit him with her car. She didn't choose to hit him with her car. She did not kill him. In Karen Reed discussing why she was looking for an attorney and why she hired an attorney the morning that John O'Keefe was found, she talked about going back to John O'Keefe's home where his family was gathering after they left the hospital. She said that when she got to their home, John's family and mother had gotten there before her. Her Lexus was still parked in the driveway. We saw some of the footage of her and her father returning from the hospital to John O'Keefe's home during the trial. She said when she got into the home, it was her assumption that John O'Keefe's mother had seen her broken taillight. I think she said specifically her cracked taillight, and she believed that John O'Keefe's mom thought she had something to do with hurting John O'Keefe. She said that his mother was looking at her very warily, and she believed at that point that John O'Keefe's mom thought she had something to do with what happened to John. It's a very interesting statement in hindsight that she's like, oh, she must have thought I did something because I have a cracked taillight. So Karen Reed is telling the interviewer that from the time she got back on the Section 12 hold, that she thought the taillight made it look like she hit John O'Keefe with her car, which I found interesting. She said that when she decided to leave John O'Keefe's home, she told someone at the home, quote, I think John's mother thinks I did something to her son, and that's why she decided to get an attorney. It is always a good idea to get an attorney. I didn't know that she had hired Yannetti the same day until it came up in trial. The Commonwealth asserted that the defense had opened the door to allow that in. They had a hearing about it. The judge didn't let it in. The Commonwealth was trying to push in a conversation about Karen Read retaining an attorney. You can't comment on someone retaining an attorney. You can't comment on their silence. You can't use the fact that somebody hired an attorney, which is why the motion was denied. And this is why I'm always so thankful to record with the Law Nerd Chat, because they reminded me that it just got into the motion hearing and the court did not allow that in. I remember the prosecution arguing in that motion that she hadn't Googled like a DUI attorney. She was looking for something more significant than that. But what if any person driving wasn't a DUI that evening, it seems? And in the 2020 interview, Karen Read said she had 4 drinks. We know that the Commonwealth alleges that she had 9 drinks, but there were some questions about those 9 drinks and on the video. And did she drink them all or did she not drink them all? She says she only had 4. She did say she was buzzed, but she thought she could still drive. And we also learned how Alan Jackson came to be on this case. Alan Jackson said that he received an email from Karen Read, and the subject line of the email was something like Boston cop murder. And that is what prompted him to open up the email. He did say he gets a lot of emails, but that in the email, she included all of the autopsy photos as well. And Alan Jackson told the interviewer that when he was going through those autopsy photos, that it became apparent to him that John O'Keefe had not been struck by a car. And that is why he decided to join the defense team in this case. But it was Karen Read reaching out to him directly with those autopsy photos. The episode then addresses the autopsy photos being used in court, that John O'Keefe's family was not happy with the autopsy photos being shown and used on giant poster boards in court for different motion arguments. But the one thing that is very true about defense work is there are things that defense attorneys will argue and will say in court that can often be distasteful to the general public, because vigorous advocacy cares about one thing only, and that is the defendant. And we saw some of that showing in Alan Jackson's interview and in statements he made directed at DA Michael Morrissey. They showed a clip of Alan Jackson talking outside of court on the courthouse steps, talking directly to elected Norfolk DA Michael Morrissey, saying, "I'll speak slow so you can understand." I was like, ooh, that is not stuff you can say if you were the DA, Alan Jackson. But also, because I watched the trial starting at the trial, you see a little bit of the animosity creeping into this case before it even got to trial with statements like that. And I think that's where we saw the judge treating the 2 defense attorneys a bit differently. You could tell that there was not a lot of love lost for Alan Jackson from her. So at the end of the episode, it seems that what the new parts of the episode was Karen Read right before the trial began, staying in a hotel, clarifying that she doesn't have a car, she doesn't have a license. The license automatically gets taken with charges like these in most states, so that doesn't surprise me. That it was easier for her to meet with her attorneys staying in a hotel. She talked about her trial clothes, saying that was her intention to dress like her legal team. She thought that that was the appropriate amount of respect to give court proceedings, and that was what she was trying to achieve with her court-selected wardrobe. And it showed her talking about the fact that she had kind of accounted for all possibilities. I wonder if the thing that she didn't account for was this being a hung jury, because she talked about planning what she would do if she's convicted, thinking about where she would celebrate if she was acquitted, what she wants her life to look like, how she wants to move out of her home. She talked about the fact that law enforcement had come into her home 3 times. Twice they arrested her, and all 3 times they took her cell phones. And she said once that's kind of been breached, you don't want to be there anymore. So she talked about what it looks like for her next. And she talked about how difficult the limbo of waiting for trial was. I wonder how difficult it is now waiting for this retrial. And it leaves everybody in limbo without answers. The victim's friends and family, Karen Read, and all of the attorneys. The attorneys that are going to be the busiest in this are the district attorneys, because the Norfolk County DA's office and the Massachusetts State Police are dealing with fallout, not just from this case and from Trooper Proctor, but also from the Sandra Birchmore case and everything that has come to light now that there are federal prosecution of the Stoughton police officer Farwell after it was investigated in part by state police and not ruled to be a homicide, even though that is not what the feds determined. With all of that, I think the fallout from the Proctor stuff is still going to be bigger than the fallout from the 2020 interview. As to Karen Read, they can only use statements against interest against her. I didn't see any statements in this interview that I went, I wonder if they'll use that. I think if she testifies differently than what she says in the interview, then it could come up. I don't know if she will testify at a retrial. I wonder if her attorneys are looking at the reaction to the interview online to determine how the public is reacting to it, to determine how people perceive Karen Read when she is speaking to them on a national audience, and use it a little bit as a focus group on whether or not they will have Karen Read testify. Ultimately, it is her choice made at the advice of her counsel, but that might be the difference we see when this goes to retrial. What if any retrial there is in January 2025? Because with everything that we've seen happen between the end of the trial this summer and September, I imagine there's going to be a lot more to come. And don't forget, the defense said they are appealing the denial of the motion to dismiss. So there's a lot of litigation left here. Let me know what your questions are down below. Thank you for being here. Thank you for being a law nerd. We have some other cases to catch up with next week. And then we are going to be getting into live trial coverage again. 2024 is the year of court casting. There have been quite a lot of trials this year, and we will be getting into trial again, this time in Tallahassee, Florida, because Donna Adelson is getting ready to go to trial. And for those of you that have been following that story for the last decade, I am very interested to see if she will be testifying on her own behalf, like her son did before he was convicted for the same charges: murder, conspiracy to commit murder. So with all of it, make sure you have the Law Nerd app so you can stay in the loop. Thank you for being here. Thank you for being a Law Nerd. Say it with me. May your Wi-Fi be strong. May your toilet paper be plentiful. May your family be well. And may the odds be ever in your favor. Thank you for being a Law Nerd. I'll see you on stream. You can stay up to date with everything I'm covering on our free iOS and Android app at lawnerdapp.com, or search your app store for Law Nerd. And you can also follow me on social media at the Emily D. Baker. Remember, I stream on YouTube on Tuesdays and Thursdays. I recap all of that for you in quick bits on Monday. And of course, the Emily Show drops on Wednesdays. Thanks for being a Law Nerd.